Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
All right, we take you now to More Law Connection, where attorney Dan Moore is answering viewer emails. Good morning, Dan.
Morning, Deb. Today our first question is from Barb. She asked, I have a relative who got one of the steroid injections that could have led to meningitis. They haven't had any symptoms so far, but can they sue the manufacturer? This is one of those terribly unfortunate circumstances where you go to the doctor to get treatment and unfortunately you get worse instead of better. And for those of you who don't know, the steroid injections that we're talking about are usually administered in the spine or in your elbow or shoulder, usually joint injections to help with some sort of problem you've got with your joint. Now, generally speaking, if you don't have an injury, you don't have a claim. There are some circumstances where you might be able to pursue a cause of action for emotional harm, but if you have no injury, even if it's just a little bit of emotional harm, it's typically not going to be something a lawyer or you want to pursue because the cost of it's going to be too much to recover anything substantial. So my advice to you is go to your doctor, make sure you know the symptoms that you need to be looking for to detect an injury. If one of those symptoms manifests itself, then immediately go back to the doctor, but then that's also when you may have a claim, a legal claim that is, that might be worth pursuing. Deb, back to you.
All right, thanks a lot, Dan. If you're just joining us at home, our topic today is personal injury. We're joined by Mark Napier. Thanks again for being here.
Thank you, Deb and Don.
Hey, I think y'all wanted to elaborate a little bit on Dan's email question there.
Yeah, you know, what a timely question. We did a little checking. This fungal meningitis is what these people are having trouble with. And the CDC says complications are dehydration, brain damage, death, hearing loss, learning disabilities. My goodness. And this is because a person's got either a neck or a back injury and they've gone in to get an injection to try and decrease the inflammation and decrease the pain. Lawyers who handle personal injury cases often have clients who have those types of injections because they kind of go along with spinal injuries. And this is a clear example of products liability. So far, 15 people dead, 200 sick. Mark, this is something you've seen, haven't you?
Yes, unfortunately we have done. Products liability is that area of law that holds unsafe manufacturers accountable for the harm they cause. And there's basically two theories, so to speak. One is what is called basically a manufacturing defect, or it could be a design defect. It sounds like here it was more of a manufacturing when the product was produced, that somehow the fungi meningitis got into the product, the packaging, or whatever. And it is very sad that that has caused people who already have injuries to aggravate those injuries and, of course, incur other injuries or conditions. So it is sad.
It is sad and it's scary, too. Let's go ahead.
Well, there's just one other thing I think is interesting, sorry. But I think it's important to know. This company was actually cited for safety violations repeatedly prior to this outbreak. That's what the news reports indicate.
I understand that's true. So they should have been on more of a heightened, we'll say, care standard, since they'd already been cited for potential problems in their manufacturing or their packaging, and they had health and safety issues. It's really egregious for them to allow this to occur.
Right.
So I promise I won't interrupt this.
Oh, that's okay. We're all family. Let's go to Alan in Foster, Kentucky. Alan, I understand you have there's a store that you were at and a terrible accident.
Yes. I lost one of my fingers at a store, and I was curious whether they was responsible for the accident that happened on their property or not.
Alan, tell us a little bit more about how you lost your finger, because if the only connection is it happened on their property and they didn't do anything wrong, they don't owe you anything. Tell us more.
It was a compressor cooler. I was helping somebody load a compressor cooler on the front of their property. Okay. And I pushed the cooler over on the trailer, and it cut the end of my finger off.
So you pushed the cooler, and basically your finger got caught and amputated. Is that right?
Yeah, amputated it off.
I don't think basically it doesn't sound like they did anything wrong. If they didn't do anything wrong, they owe you no obligation. Mark, do you have anything to add to that?
No, Alan, I'd have to agree with Don that if in fact the premises owner or occupier did nothing wrong to cause the injury, then unfortunately there is no claim to bring. For any type of negligence claim, you have to first prove that they owed you a duty and that in some way they breached that duty. Another way to put it is that they used a lack of reasonable care. But in these circumstances, it sounds like it may have just been an unfortunate accident, and under those circumstances, you may not have a claim to pursue.
Okay, let's go back to Dan Moore. Go ahead, Dan.
All right, Deb. Our next question is from Michelle. She wants to know, what happens if I refuse to do a breathalyzer test? This is probably the most common, or one of the most common, certainly, questions that involves DUI law. And it's something that is oftentimes confused. There are two types of breathalyzer tests that people should be aware of. There's the roadside breathalyzer test that kind of goes along with the roadside test, the walk and turn, the watch the pin test, all those kinds of things. And then there's the test back at the station. The roadside breathalyzer test, you don't have to take, and if you refuse to take it, there are no consequences. There is a station test that I just mentioned, that if you're arrested and taken back to the station, if you refuse that one, you have the right to. If you refuse it, though, you're going to get a license suspension. And that license suspension is most likely going to stick, even if you're ultimately found not guilty of the underlying DUI. So there's some consequences there you should be aware of. Now, if you have a question, go to fox19.com, go to the More Law link, and click the Send Us Your Question form, fill it out, send it in, and we'll do our best to answer your question. You should know that we get lots of questions, and we want to do the best to help everybody out we can. So, Deb, I'm out of here. Hope you guys have a good rest of the show.
We will try to hold down the fort. We're going to take a break right now, but please give us a call, 513-421-4691, if you have a question about personal injury. The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show. So today we have Mark Napier from Freaking and Betts. You can get in touch with him at 513-721-1975. And Don Moore, the Moore Law Firm, 513-232-2000 or morelaw.com. And you can get all the information about the show at fox19.com by clicking on More Law. Now, Don, you were involved in a case and you wanted to show the viewers some pictures of what happened.
Yeah, actually, we brought a little picture today. And it basically shows a wrecked car, but that's not what the case is really about. What the case is really about was a trucking company that sent 50 trucks a day all over the greater Cincinnati area in violation of ICC regulations. And the way they violated the regulations is they failed to tell the drivers or give the drivers sufficient information to determine the height of their load. And the way this car got torn up that way, and the way my client got so terribly injured, was that this driver did not know how high the forklift was on the back of his truck. And as he drove under an overpass, it knocked the forklift off right onto her car, which was going the opposite direction. This lady didn't do a thing wrong, and she suffered a real bad injury. And frankly, it was predictable and it was preventable because that trucking company never let their drivers know exactly how high their loads were every day. And a couple of times a year, they would hit overhead things because of that. And that's just something that goes on. It can affect everybody.
Right. What a scary situation, too. You're driving down the road and this just comes flying at you.
Yeah, you're not kidding.
Hard to imagine.
And it is one of the things that we do, actually, is we try and, by representing our clients, not only help them, but also try and make things safer.
Safer, absolutely. All right, let's head back to the phones now. We have Valerie in Cincinnati. Valerie, you were in the hospital and something happened, I understand?
Yes.
Can you tell us a little bit more about it?
Yes, I was in the emergency room and I was getting a procedure done, and I had tried to lift up because I was sliding down in the bed, and the bed rail broke and I fell out the bed. And I was wondering how long does the statute of limitations allow me to file a claim?
That's a very good question. Actually, it's potentially 2 claims, huh, Mark?
It is. That is a good question, Valerie, and my answer would be this. You need to take the most conservative statute of limitations here, which for a medical claim, and that again would include something perhaps that you're describing since it occurred in a hospital, that has a 1-year statute of limitations. There also could be maybe a product liability claim. If in fact the bed or the railing was defective in some manner, then there may be a product liability claim which has a 2-year statute of limitations. So again, don't wait too long to have this investigated to determine who are the potential defendants and so forth.
Don?
Well, just one other thing, and as Mark said accurately, there's a 1-year statute of limitations for med mal. If you send out a special statutory letter, and you should get a lawyer to do that for you, and you do that before the 1 year expires, you can get a 180-day extension. Not something we like to do, but you need to know that it's an available option.
Okay. All right, let's get to another call now. We have Tim in Bromley. Tim, this is about a car accident?
Yes. I was stopped and the car behind me drove right up into me. We both had the same insurance company. The insurance company, Part A, immediately wrote me a check for my car, and then I took the quickie settlement, Part B, that paid for my hospital visit. I didn't have any injuries. It was just, it was whiplash type thing. So I took the quick settlement. They wrote me a check for $2,000, and I agreed. Now, a year and a half later, I'm having neck, shoulder, and back pain, and I go to the chiropractor at least once a month. Is there anything I can do to
Sure. To figure out, I would think that this can be common. You're in an accident and you don't really think you're injured, and then later on symptoms develop.
Yes, Pam, it's unfortunate that you're now having these symptoms, but the reality is that if you didn't have any symptoms or injuries at the beginning, it's going to be difficult down the road, of course, a year and a half later, to show that this accident, which didn't cause you any immediate or even nearly immediate symptoms, has caused you symptoms that are a year and a half later. It's possible, but since you didn't see a physician, it makes it difficult to prove. Now, the other problem, of course, is that you apparently have signed a release in exchange for the money. The only thing I would tell you in the future is that wait a bit to see, in fact, if you do have some symptoms. And if you have any questions, consult with an attorney. And most attorneys will talk to you on the phone for free. They won't charge you for the phone conversation, or even if you come in for a short consultation in the office. So all I can say is next time, don't be so quick to take the quickie settlement, so to speak, and see if your injuries do develop. You have up to 2 years. Now, it can be shorter sometimes in Kentucky, but even in Kentucky, you're going to have 2 years.
Okay. That's about all the time we have for today.
I think that's it. One thing people need to know, 1/3 fee agreement is typical in a case like he was just talking about.
Okay. Mark Napier, thanks for joining us today.
Thank you, Deb.
Next week, we will be talking about landlords and tenants. Until then, this is More Law for Today. We'll see you next Monday.